Good evening, friends, and happy Lodi. And as the festive season starts, we thought as the warmness brings in the Lodi up down in Punjab and Haryana, we thought why not hit ourselves with the knowledge of the New Evidence Act, BNS as we understand. What is the general overview of the changes in the Evidence Act? While we were thinking about it, so we thought that though his name is Yuvraj, but he's king in the matters of electronic evidence once we understand those nuances. We have already done 3 sessions with him. We've also done 1 session in respect of the book which he has written, which continues to be one of the best sellers in the electronic evidence in the courtroom, a lawyer's manual by LexisNexis. Those who have not read it or those who are not knowing about it, they can also read that. They can buy the books from the different platforms like Amazon, etc. And when we have Yuvraj, we can understand that true to his name, he shares the knowledge in a very insightful, deeper dive of this subject. And in fact, few of the interns had come today in the office. We were always asking him to watch certain videos. So they said, so Mr. Yuvraj has taken few sessions or not. So I shared that knowledge with them. I said that just watch this link with them. They said, Sir, aaj maza aaya, meaning thereby that they have truly understood that. They said, today, sir, it's Lodi, but still we will watch this. So that's the type of flavor, what you say, he adds with his knowledge. Over to you, Raj, and thank you for accepting the invite on behalf of Beyond Law CLC.
Thank you so much, Vikashji, for that very kind introduction on your part. Am I audible properly to everyone? Yes. So let us begin.
At the end of the session, we will be taking questions on the Zoom chat as well as from the YouTube. Over to you.
So it's actually always a pleasure to be amongst Beyond Law team and with you all. One of the very rare platforms where only thing that is shared is the knowledge. And therefore, it's always a great pleasure to be back. Today, my topic is the treatment of electronic evidence under the New Evidence Act. And I must tell you, I would also be dealing with the changes which are brought in the new New Evidence Act, which is called as a Bharatiya Sakshya Bill or Bharatiya Sakshya Adhiniyam. And I must tell you, frankly speaking, let us have this very practical session. At the end of the session, I genuinely expect all of you to be aware of all the nitty-gritties of the New Evidence Act, and let us keep the session short and sweet. And any one of you, if they have any doubts, please reserve it at the end and we will deal with all of them. And let me give you the brief overview. Now, what we are looking at is a Bharatiya Sakshya Bill. What we were looking at earlier was Indian Evidence Act of 1872. There, the name is obviously changed. It's a Hindi version of the name now, or maybe in fact a Sanskrit version of it. But there are some very fundamental changes. And let me tell you, the changes look small. If you go by the proportion, they may not be, hardly a few percent of the entire act. But as we all know, if you put a salt, even if you increase the salt by 1%, the entire texture of the dish changes. So basically, you can't measure the salt by the percentage. You have to look at it from the effect it has on the entire scheme of the things. And from that perspective, let me tell you very frankly, friends, these amendments which have been brought are going to have a far-reaching effect on the Indian jurisprudence. And we are going to discuss how it's going to, how we have to combat with some of the challenges that the new act has thrown at us. Let me first tell you, our strength as an advocate is always reciting the section, at the spur of the moment, that, the section 27 statement is not admissible unless it leads to a discovery, is a common thing that you will hear in criminal courts. Now, you do not have a luxury of, if I may use the word, throwing the sections like that, because you will have to go back to a statute and then read what number now that section has got. So that kind of, that aura that generally these kind of the lawyers have, who have recited the sections by heart, that is now going to fade a little. And therefore, the first thing that I would be doing while I am talking to you is to tell you how the structurally it has undergone a change and how substantially it has undergone a change. So you would be able to also then connect the sections कि जो पहले 27 था तो अभी क्या बन गया. You know, I want you to also know that while we go along, so you have kind of not complete mastery, but at least a hands-on command over the new legislation. So let us begin. Let me tell you the first change. We earlier had 167 sections in our Indian Evidence Act. Now you have 170 sections. Those of you who have a luxury of having the mobile or some other device apart from the device on which you are hearing me, please have the two sections or two acts side by side. So at the end of the session, you would be able to, very easily juggle between the two. Let me tell you why there is a basically increase in the number of sections. That is because of a very important reason. Some of the sections have been consolidated. Earlier, those were 3-4 sections. Now they are made into one. And there are some cases where one section has been broken into several parts, and that has led to the increase and decrease in the number of sections. Per se, there is not introduction of any new concept as such, like an estoppel we have as a concept. We have adverse inference as a concept. There is no introduction of new concept except one concept with which we will deal in shortly is about electronic evidence. Apart from that, please take note that conceptually there is no material difference between the old act and the new act except 3 to 4 things that we are going to discuss. Now let me tell you why the initial reduction of number of section. If you look at the old section 2 of the Indian Evidence Act as we had, that was repealed long back in the year, if I remember correctly, 1938. That section was repealed way back. But that section still had its presence in the book. Now you would see in the new act, obviously since that section was gone, they have removed that section 2 and they have taken up section 3 up. So the section 3 goes up. So what was earlier section 3 now becomes section 2. They also changed the name. Earlier section 3 was called as an interpretation clause. Now they call it as a definition clause. Okay. If you go deeper into it, you will not see any material difference between the definitions and the interpretations. Again, so you had a -1, correct? Because what was earlier 3 has become 2, so -1. Now you have -2. Because if you look at the old act, you have what is called as a may presume, shall presume, and conclusive proof. That was a definition that you had at section number 4 in the old act. Now, in the new act, that has been made part of section 2, definition clause. So basically that has been subsumed in section 2, definition clause, rightly so, because ultimately you are defining may presume, shall presume. So why not to put that into definition clause? That's what they have done. So now you have what count? -2. So what was earlier section 5 is now going to become section 3. What was earlier section 7 is going to become section 5. So that's a very easy way to remember the new arrangement of section. This -2 count continues till you reach what is known as admissions part, which used to begin earlier at section 17. Now that, as probably you would see in the new act, that would now become section 15, -2. Now admission part earlier contained 16 sections. Okay. This new part of the Bharatiya Sakshya Bill now will contain 11 sections. Please note, again you have reduction of how many? 5 sections. Earlier it had 16, now it has 11. Now you may ask me, where has these sections gone? These sections haven't gone anywhere. It is again subsuming the sections. They have absorbed another section into body of one. For example, if you see section 22A of our old act, those of you who have it, please have a look. It pertains to oral admissions about contents of electronic record. That has now been removed. Why, I will tell you shortly. Then another part of the admissions, very important part, so to say, for my criminal lawyer friends, was section 27. Suppose if a offender gives some information in the police custody, that is obviously not admissible because there is a possibility of it being under coercion. But section said that much of an information that leads to the discovery will be admissible. That is the soul and substance of section 27. After that, in the old Act, friends, you will see that there is section 28, 29, 30, 31. No, now what earlier was section 27 has now become section 23. And 3 or 4 sections of the old Act have now been made part of section 23. So section 23 has been consolidated, and therefore that is the reduction of number of sections you get in the admission. So why the reduction from 16 to 11 is because of this consolidation and because of removal of section 22A. Okay. Important section which we also invoked was section 32. You all know dying declaration was admissible under section 32 earlier. So please now note that has become section 26. That is -6 rule, that because -2 became -6 after the chapter of admission. So now what was 32 has now become section 26. Let me pause here for a minute. What I'm trying to tell you is structurally I'm trying to explain you the change, because as a lawyers we have to have that kind of little command over the new act. That's the endeavor. I am not touching the contents. Please note, I'll be touching the contents as and when I think it's relevant, or maybe a little later in my lecture. But let me deal with one very important change before I proceed further structurally. That is the definition of the word document. Please go to the definition of the word document if you have it handy in the new act. Earlier, you would see the word document was not defined to include the electronic record. Those of you who have the advantage of having this section, please note, document definition was not amended in the year 2000 when the Information Technology Act was enacted. What was changed was the definition of evidence to include the electronic record, but document per se was not changed. But the new act specifically amends the word document to include electronic record. Please note this very, very important change, which is going to be of relevance to us when we discuss the electronic records. So the word now document includes electronic record. So please understand this. So apart from this major change, the rest of the definition clause remains untouched. Let's now move a little bit. Section 45, as you would all know, used to deal with expert evidence earlier. Now, section 45, numbering has changed because of that -6 and -8 now ratio, and now it is section 39 of the new act. Most importantly, earlier what was section 45A, which pertained to examination of an electronic record, has now been subsumed in section 39. Let me explain. Earlier, whenever court wanted to form any opinion about any electronic record, it could take help of an electronic expert. Okay, this concept remains the same, but that was titled as section 45A in the old act. Now, legislature in its right wisdom has made it a part of section 39 for an obvious reason, that examiner of electronic record is also an expert. So why to make it a separate section? So they have made it a part of section 39 subsection 2. So 45A has lost its existence. It has been now subsumed in section 39. I am only telling you the important milestone. As the practicing lawyers, we have to deal on a day-to-day basis. Because if we go threadbare, it would be a quite long session. I'll be just focusing on the milestones which have undergone a change. Now, importantly, expert evidence portion earlier had 9 sections. Now it has only 7 sections. Okay. Because of the reason that I just told you. Now let us come to something that is of day-to-day concern to us, and which is a focal point of today's lecture, the electronic evidence. And let me tell you very frankly, what this act has changed tremendously is the electronic evidence. Unfortunately, there hasn't been much debate about it, but as practicing lawyers, you would very soon realize the impact it's going to have on the court system. I had in fact written an article on live law. I had also written to the Law Commission and the Lok Sabha, and I had suggested few changes. Few of them have been recognized, and those of which are not recognized are going to be a source of headache. I'm just trying to now summarize what was the position earlier. Those of you who have witnessed my earlier lecture probably would be in a better position to understand, but I won't resume that. So let me just give 5 minutes for a flashback. Earlier, Indian Evidence Act had three categories of evidence. One was oral evidence, fine. Another was documentary evidence, जिसमें आपका था primary and secondary evidence, and then you had what is called as an electronic evidence. Documentary evidence के sections दो ही थे, 59 and 60, fine. Oral evidence sections were only two, 59 and 60. That the contents of document may be proved, everything can be proved by oral evidence except the contents of document. That was section 59, and section 60 was direct evidence. So for oral evidence, you had two sections. For documentary evidence, you had sections beginning from 61, fine. And for electronic evidence, you had what is called as a 65A and 65B. So correct, there were three categories. Now there are, so to speak, only two categories. Electronic evidence per se as a category has been removed from the body of the act. If you remember, in Navjot Sandhu, the Supreme Court said that if it's an electronic evidence, please do not use the modality of, you can use the modality of documentary evidence, because section 65, as it earlier stood, the court said electronic evidence is nothing but a secondary evidence, so you can prove it in the same manner as you prove the secondary evidence. This is what the court held in 2005 in Navjot Sandhu's case. Don't worry, don't look at the where act now. You can just focus on my submission, so you probably would be able to understand it better. In Navjot Sandhu, the Supreme Court said electronic evidence can be proved as a secondary evidence. And then floodgate opened. Everyone forgot about 65, 65B. Everyone started putting it as a secondary evidence, as if it's a documentary evidence. Then came the judgment of Anwar versus Bashir, where the Supreme Court said, sorry, you cannot use the secondary evidence door when you have a separate section of section 65 and section 65B. You have to use only the modality of 65B when it comes to electronic record, correct? Because of the word notwithstanding anything contained in the act that you found in at the beginning of section 65B. So court said, please do not look at anything. You have to go only by the modality of 65B. After the Honorable Supreme Court took this view in Anwar versus Bashir, that was subsequently confirmed in Arjun Pandit Rao Khudkar judgment by Justice Nariman, who said that you have to specifically prove the electronic record in tune with 65A and 65B. Please do not look at documentary evidence at all. That chapter does not matter. 61 to 65 does not matter for you. Just focus on 65A, 65B. Now, what the legislature did in the new Bharatiya Saksha Adhiniyam is very interesting. Firstly, let me just come back to the structural change. Earlier, what was section 59 and 60 of the oral evidence has now become 54 and 55. Forget about it. Let's not deviate from the topic. Except that structure, everything remains the same. Please now look at section 57 of the new Saksha Adhiniyam. So, very interesting section that completely topples the entire jurisprudence upside down. Section 57 of the new act says something very interesting. Those of you, I'm just giving you time to just go to section 57, because that is what probably would retain us for next 5 minutes. Earlier prime section, as you all aware, section 62 earlier defined primary evidence. It said when the document itself is produced for inspection of the court, it is a primary evidence. Understood? Fine. And it had, if you remember, two explanations, the earlier version. The one explanation dealt with documents made by the documents in counterparts. Another dealt with the documents made by a common process. Two explanations. Now, these explanations have been increased, and now there are 7 explanations to section 57, earlier section 62. So, primary evidence has been expanded to include electronic record. And therefore, if you look at the newly added explanations, you would see something very interesting. Explanation 4, explanation 5, explanation 6, and explanation 7 specifically deal with electronic record, and it says, explanation 4 says, pardon me for structural differences, I'm just conveying you the spirit of it. Explanation 4 says when the electronic record is stored simultaneously in multiple files, each file is a primary evidence. I'll give you an example. Suppose if I am recording something on my mobile, I have an iPhone. When I'm recording something with my iPhone, the iPhone users would know it would also get recorded maybe in iCloud. Frankly speaking, it doesn't happen simultaneously. It happens after I store it my device. The buffering takes place little later. But assume for a minute that it is being recorded simultaneously in the cloud storage somewhere else. This explanation says that not only what my mobile records is a primary evidence, what is being recorded in the cloud storage is also primary evidence. Earlier, if you remember, I'll take you there maybe in a short while. Earlier, this was called as a copy of the original. So the lawyers used to argue that no, my lords, what is being produced before the court is not the mobile footage. What is being produced is a cloud storage. That is a secondary evidence. This explanation says no. When electronic record is created and stored simultaneously, each file is a primary evidence. So understand this. So the primary evidence definition has been expanded. Please come to explanation 5. It says when electronic record is produced from a proper custody, it is a primary evidence unless it is disputed. Very interesting concept. Suppose I have this mobile, I have some footage. I produce it. Irrespective of anything, the court will say this is a primary evidence because it is coming from a proper custody, because I am the owner of this mobile. This is the concept of a proper custody. Assume for a minute that in a matrimonial litigation, I take mobile of my wife and I want to prove something. Will that be from a proper custody? It won't be from a proper custody, because the proper custodian of this mobile will be my wife. And therefore, that very moment, this electronic record will cease to be a primary evidence. It will no longer be a primary evidence. Therefore, the explanation 5 is very important. It must be from a proper custody. And if it is disputed that it is not a proper custody, the burden will lie on the person who says that it is not a proper custody. It's a reverse burden of proof. Please come to explanation 6, which is kind of a replica of explanation 4, which says that when the video recording is being simultaneously recorded, but a distinguishing factor comes which says not only recorded but broadcasted and transferred to another, each of the stored recording is a primary evidence. Let me give you an example. I record something with my mobile. I feel that there is a possibility of my mobile going corrupt or getting reset. Let me transfer it to my friend's phone. What I do, I transmit my record, I transfer my record. Explanation 6 says even my friend's mobile will be a primary evidence because it is a video recording which has been transferred and transmitted to another device, and each of the stored recording is a primary evidence. Therefore, now the primary evidence concept has undergone a sea change. Come to explanation 7. Again, kind of you would visual similarity. When an electronic record is stored in multiple storage spaces in a computer spaces, each of such automated storage, including temporary file, is a primary evidence. Sounds a little complicated, I'll explain it for you. Whenever I store something in my computer or in my device, without you people knowing it, that document or that file gets recorded at multiple places within the same device. For example, if you're typing your writ petition on a laptop, you would see, if suppose the light goes off, if the laptop gets shut abruptly, when you open it, you would see a file being written by the word for you to save, saying that, did you want to save this? Now, where was this file saved? I didn't save it. That was on the RAM, what is called as a random access memory or a temporary storage. Did I do it deliberately? No. And therefore, it is called as an automated storage, which happens without my intervention. And therefore, the word automated storage finds a reference in explanation 7. Now, the law tells me, the new Sakshi Adhiniyam tells me, that this temporary file is also primary evidence as your main file on the window platform. So, they both have the same status. You may not understand the technical importance of this similarity immediately, but in IPR suits, something found on RAM has been held to be IPR infringement. And those of you who want to dig deeper into it, you can Google it maybe after the session, and you would understand the importance of RAM memory being called as a primary evidence in IPR litigations. So please understand the primary evidence definition has been expanded. Now please come to what is now section 67. I'm sorry, section 61. And here the entire electronic evidence jurisprudence changes. First, if you look at section 61, it says nothing in this adhiniyam shall apply to deny the admissibility of any electronic record on the ground that it is an electronic record and such record shall have the same sanctity as if it's a paper record. As if, please don't treat this as a mobile, treat it as an ordinary document, is what section 61 says. And look at the words, nothing in this adhiniyam shall apply to deny the admissibility. I won't revisit my earlier session. Those of you are interested can go back. We had spoken at length about the admissibility and relevancy. Conceptually, they are different. We are only on the admissibility. So what does this section convey? That only you cannot discriminate against the mobile device because it is a mobile. You please treat it as a paper record. Now, tell me one thing. If this was so, if you are treating it as a documentary evidence, if you are expanding the scope of definition of primary evidence, was it then necessary to retain 65B? Technically, no. Because why you required 65B? Because you treated electronic record differently. As the Honorable Supreme Court said in Arjun Pandit Rao, that please treat it differently, don't treat it with the documentary evidence. Now, what does the Act do? The new Act, it says no. Firstly, it expands the scope of primary evidence to bring this mobile at par with paper documents. It again reaffirms the position by section 61 by saying that nothing in this adhiniyam shall apply to deny the admissibility. So you can't discriminate against the electronic evidence, treat it as a paper document. Then any logical person will then feel that then goes out old section 65B. Now I can prove mobile like I am proving the paper document. Unfortunately, that is not so. Unfortunately, section 65B makes its reappearance in the form of section 63. And section 63 begins with the word notwithstanding anything contained in this adhiniyam. Exactly the same word that the Honorable Supreme Court in the case of Anwar versus Bashir and in the case of Arjun Pandit Rao Khudkar used to give an overriding effect to 65B over other sections dealing with documentary evidence. Now look at the conflict. On one hand, section 61 says nothing in this adhiniyam shall apply. So it is again a supersession clause. 63 says notwithstanding anything contained in this adhiniyam. Again, it is a supersession clause. As a litigant, suppose if I have to prove this mobile in the court of law, and if I go to the court and say, my lords, please take this mobile on record because this is a primary evidence because of explanation 6. The court will say, sorry, look at section 63. It says notwithstanding. You cannot fall back to that section at all. It is notwithstanding. It means non-obstante. It means it will prevail over even section 57. Therefore, this conflict between section 61 and 63 is going to be a source of pain for all of us in the times to come. Because whenever me as a proponent of electronic record, I am going to project this as a primary evidence, the other side is immediately going to spring into action and going to rely on the word notwithstanding anything contained in this adhiniyam and say that please don't look at anything, look at judgment of Anwar versus Bashir, which says that notwithstanding prevails over every single thing. And the proponent of electronic record like me will say, sorry, look at the word nothing in section 61 and therefore 61 prevails over 63. And respondent will say, no, 63 prevails over 61. And this conflict between two sections is going to hold us for a long, long time unless the Honorable Apex Court settles down the dust. Important change that has been brought is this. Now let us go into the body of section 63. Earlier it was section 65B. If you know, earlier section 65B, it reads very easy. It is notwithstanding anything contained in this act, any information contained in an electronic record which is printed on a paper, recorded, copied in optical or magnetic media. Yahan tak sab same hai, and then there comes one very important word, or a semiconductor memory, which was not earlier there. Essentially, on a technical front, it won't make much difference because no one really ever argued earlier also that semiconductor memory is excluded from scope of 65B. So therefore, this seems to be more of a superficial change, though obviously makes it more wide in ambit, but this is one very important change. Second change you would see, it reads like this, which is produced by a computer, or earlier it said computer system. Now it says computer or any communication device. So the word computer system has been replaced by the word communication device. Communication device would include anything from the old age pagers to the new age mobiles. It will cover everything, communication device, and therefore it has been expanded in the scope of its ambit. And then it goes on to read like a usual section. Anything contained in the electronic record printed on the paper, stored, copied, recorded in optical or magnetic media or a semiconductor memory shall be deemed to be a document if the conditions mentioned in the sections are satisfied. I will not today for a moment retain you people on what are those conditions, how to comply with them, because that has been part of my earlier session. I don't want to repeat anything there. We had spoken at length how to comply with each of those conditions and how to go about it. The point remains is this, that the conditions which were part of 65B earlier have been retained as it is in the new act. And therefore, you have to comply with each and every condition to prove the admissibility of the electronic record. And let me just brush up briefly what are those conditions at the cost of repetition, as I said, because last session was completely on it. The computer output containing the information was produced by a computer when the computer was used regularly. Examples I have given in the last session. So basically, it shouldn't be a device which was out of operation for a long time. That can't be the case. It should be used regularly. I also told you last time what is the reason for this logic. Suppose if I'm not using this mobile, let's assume for 2 years, what happens? Internal battery goes down, and the time and date is reset, and therefore it is necessary for everyone to use a device regularly, and that's why the condition comes that the device must be used regularly, and so on and so forth. Then you have condition B, condition C, condition D, and then you have what is called as a 65B certificate earlier. Now this is going to be section 63 certificate, because if you look at section 63 subsection 4, it says that if you want to give an evidence of the electronic record, then you must give a certificate, and this certificate is nothing but the old 65B certificate, and therefore exactly the same connotations will apply which used to apply in the old days. 65B has made its reappearance, if I may say, in a very splendid form now in the form of section 63. So to cut down the whole issue short, let me make a statement that whatever was earlier being done by the lawyers under 65B will have to be again done under section 63. However, if you can succeed to argue before the court that no, please do not put me through the trouble of 63 certification because my device is a primary evidence, and if the court accepts your argument, then as you are all aware, a primary evidence is a best proof of its content. It doesn't require any further proof, and therefore you may say that once I have succeeded to prove this to be a primary evidence, please don't put me through the rigors of section 63 again, old section 65B again. Earlier, there was no section that treated electronic evidence at par with documentary evidence. Now there is a section that treats documentary evidence at par with electronic evidence. This position is reaffirmed by section 61. And if you succeed in your arguments, then there is a possibility of you may be exempted from compliance of 65B or presently section 63. But let me tell you something. The word notwithstanding in section 63 is very important, and that has been interpreted by the Honorable Supreme Court in not less than 6 judgments. And this section gives overriding effect to section 63 over all other sections. Therefore, my word of advice to you would be that even if you are in the position to argue that my mobile is a primary evidence, please don't put me through the rigors of everything. My word of advice to you would be, please follow the rigors of section 63 or old section 65B to obviate any further potential challenge to the admissibility of electronic record. That's the word of advice. Let me tell you another problem that the new act has created. That I should have dealt with it when I dealt with section 57. Please go back to section 57. I'll tell you what is the problem. Section 57 talks of primary evidence. Now, section 57, when spoke of primary evidence, it should have cross-referred to section 63 also. Unfortunately, that has not been done. and that's going to again create section 61 also, but that's going to create some problems. These both sections should have been read together. Another section is section 61, which is improperly worded in my opinion. Section 61 says that you cannot deny admissibility of any electronic record, and it will be as if it's a paper record. Now, friends, if you would see the Indian Evidence Act, there is nothing called as a paper record. It is not defined. What is there in the Evidence Act is a documentary record, documents. You cannot use the word so loosely. I'll tell you the reason for it. The reason is this, that paper record can also be the electronic record. For example, suppose if I print a photo from this mobile on a paper, is it not a paper record? It is a paper record, because if you look at the section 65B earlier or presently section 60, what does it say? Section 63, any information which is printed on a paper will also be an electronic record. Therefore, paper need not mean documentary evidence. Paper record is a different category altogether. It is not, does not mean the documentary evidence is a different thing, and paper record is a different thing. Therefore, the section 61 should have used the word that this will be treated as a documentary record and shouldn't have said paper record. Using the word paper record loosely is going to remove the immunity that the documentary evidence has generally in the scheme of Evidence Act. And one may even argue that, primary evidence is applicable only for a documentary evidence. It doesn't apply to paper record. Paper record may be even an electronic record. Correct? Paper record can be, suppose if I have to prove the email in the court, what do? I take a paper printout. It's a paper record. But does it cease to be an electronic record? No, it is still an electronic record. And therefore 65E and now section 63 uses the word printed on a paper. And therefore, paper record would still keep it an electronic record only. It will not change the complexion of the nature of evidence. And therefore, section 61 should have used the word documentary evidence. You should have treated electronic record at par with documentary evidence. Instead, you chose to treat it at par with paper record, which is going to cause some confusion. That's what my take on this. Another. Now, let me deviate from the electronic record topic for a moment and let me tell you what other changes the new act has brought. The most important change, in my opinion, is, if you remember, earlier we had what is called as, obviously we still have section 58 and section 63. The new act would be section 58. The old act will have section 63, which had defined the words secondary evidence for us. You're all aware, when the original is made from when the copies are made from the original, we call it a secondary evidence. Earlier, the section 63 had only 5 categories. Now it has 8 categories. So the definition of secondary evidence word as such has been expanded. Now, which 3 categories are added to secondary evidence? Now, I'm not talking of electronic record. Now I'm talking of a general evidence. You all are aware that when the original was in the custody or possession of someone else, or if the original was lost or destroyed, or old section 65, then you are entitled to give the secondary evidence, and there are certain other contingencies. Therefore, I'll take you there shortly. There is going to be a problem. Now, secondary evidence word has been expanded to include 3 more categories. First category is oral admission, second category is written admission, and third category is a statement of a person who has himself seen the contents of a document, which are numerous and which are complicated. For example, if there is a statement of account running for, let's say, 3 financial years, 7 financial years, as a layman, it's very difficult for me to understand and fathom it. What I do, I appoint a chartered accountant and he gives me a summary of it. The law now says that summary given by the chartered accountant is admissible as a secondary evidence because he is an expert. Documents are numerous, documents are complicated. But I am at my ends to understand, I am not able to understand why there was a need to include oral admission and written admission as a secondary evidence. Because if you look at section 22 of the old Evidence Act, word admission, already there was a separate section which says that when the genuineness of a document is in question, you can always adduce the oral evidence. So when there was a separate section dealing with the oral admissions, there was no need to expand the scope of secondary evidence. Because assume for a minute, or let us first deal with the another section, and then I'll explain you the whole problem. Please now look at old section 65, which is now has become section 60. Section 65 in the old time told us in what situation I can give secondary evidence. And you are all aware, when the original was lost and destroyed and was out of reach of the court, when it was not easily movable and all that stuff. Now, earlier there were only 7 circumstances in which you could give the secondary evidence. If you count it, I think it should be 7. Now there are 8. And this 8th is a problem. It says that you can give the secondary evidence when the genuineness of the document is in question. Now see the problem. Genuineness of a document, if is in question, then you are already had section 22, which is still written. Then there was no need to incorporate this new section. Now what is going to happen is this. Earlier, I had to establish the grounds under section 65 in order to lead secondary evidence. Now all I have to do is this. I have to deny a document. I have to say that this document is not genuine. And then I can lead the secondary evidence of the document. It has made the task extremely easy for me to create a foundation for secondary evidence. Most importantly, and this is a little complicated for me to explain, try to see if you can get what I really mean to say. Section 65 says, I'm talking of, please understand, old section 65, now section 60. A secondary evidence of the existence, condition and contents of a documents can be given in the following cases. Genuineness is not part of the opening line. Genuineness of a document and existence of a document are 2 different things. Let me tell you. For example, if suppose this is a will of my grandfather, I say this, I don't have a will because that is probably, somewhere else which I am not able to trace. I say this is a genuine copy of it. Please record it. Please take it on record. Is this the original in existence? No. But is this a genuine? I say it's a genuine. Therefore, existence and genuine are 2 different things. 65 in its old format used to only cater to the documents whose genuineness was intact. Only problem was with existence, condition and contents. Then only 65 used to get triggered in the old time. Now, when even genuineness is in doubt, you can still go for section 65. Now section 60. That's going to create a problem. Because genuineness has to be dealt only according to section 22, according to me. It cannot be dealt with by allowing someone to produce on record the secondary evidence when the genuineness is in question. Therefore, according to me, this addition of genuineness in question to section 65B is completely incorrect, unless legislature had some other intention in mind, which probably the courts will have to speak out through the judgment. According to me, if the genuineness is in question, then where is a question of giving the secondary evidence? And according to me, this probably addition and repetition, if I may say, because please go back to section 22, you will understand what I'm trying to say. There was no need for this. So basically, these are the only changes, if I may say so, with obviously subject to correction from you all listeners, which are major changes in the scheme of the Evidence Act. Rest of the sections, according to me, in my limited reading of the new act, are largely the same. Obviously, 45A has gone, 22A has gone. There was also a section dealing with digital signatures. I think it was 47A or something that has now gone. And this is gone when I say it doesn't actually go, it is subsumed in some other section. So if you just look at the indexes in front of, just if you compare to the 2 indexes, you would understand that most of the sections are same, only the number has undergone a change, except the sections that I just told you. So friend, with this, I think I would conclude my session. Apart from this, there are not, and obviously there is one more change probably in the confession part, where it's in a joint trial, if confession made by one accused would be now admissible against other, even if that accused is absconding and all that. So I think except that minor change, rest of the confession part remains the same. Let me also tell you at this juncture that this new Evidence Act ignores certain judgments of the Honorable Apex Court. This was a golden chance for them to take into consideration the judgment of the Supreme Court. the recommendations of the Law Commission of particularly of year 2003, which had recommended to do away completely with the statements recorded in the police custody, because according to Law Commission, you cannot discriminate between the two statements recorded in police custody and recorded outside police custody. If it is leading to discovery of fact, they must be admissible. That distinction has not been dealt with, unfortunately. That still remains. But with this, let me tell you, the Indian Evidence Act in its new avatar is a commendable effort. I wouldn't say it's a completely a success. I would feel personally it is going to give rise to some other problems, and we will soon see the jurisprudence that would come in. With this, I would conclude my session. Thank you very much for your patience. And those of you, let me repeat, Vikashji, those of you who expected me to talk elaborately on the electronic evidence per se, you are please requested to visit my old sessions where I have spoken elaborately on 65B, which is now section 63, which according to me still retains its important position in the regime of the Electronic Evidence Act. Thank you so much. Thank you.
Thank you, Mr. Yuvraj. As usual, the session was quite deeper dive into the subject, and especially when, as you rightly said, the law will evolve with time. But they say that as you keep on trying, things evolve, and there are always a room for improvement in every field of life. So same would be with this provisions as we look into this. So now two questions are there on the chat. This is by Sanjay Krishna. This is not a question. He says, instead of paper record, they could have used the word phrase. E-record would be treated at par with the documentary record. This is a suggestion.
Correct.
And Vikas says that as per section 61 of the New Evidence Act, BSA, admissibility of electronic evidence cannot be denied. Then can anyone take the right of privacy ground to deny evidence, as in the earlier judgment of the Honorable Punjab and Haryana High Court in Neha vs. Vibhor had held that the spouse call conversations cannot be used in evidence, being violative of right to privacy?
No, this query tries to combine the two issues. Please see, section 61 does nothing. What does it do presently? It elevates the electronic record with the paper record. That's it, nothing more. What your question is, right of privacy, which is in fact flowing from judgment of Justice Puttaswamy versus Union of India, when the right of privacy has been held to be a fundamental right, Article 21. There, let me tell you, again, I have spoken on this, and my book contains a separate topic on this, which contains the legality of illegally obtained electronic evidence. Let me just summarize it for you. Even if any illegal evidence has been procured and it is sought to be proved in the court of law, Indian jurisprudence does not recognize the doctrine of fruits of poisonous tree, which is recognized in USA, which says that the document which has been procured illegally remains illegal, like the fruits of a poisonous tree remain poisonous, and therefore you cannot look into it. Indian jurisprudence does not acknowledge this fact. It says, as long as the evidence is relevant, as long as evidence is admissible, it would go on record irrespective of the mode of its acquisition. This jurisprudence has come from the tax cases where the raids were conducted illegally and some important evidence was obtained. Supreme Court still retains this position, saying that illegally obtained evidence has to go on record. You cannot deny the admissibility because your right to privacy is breached. Then you may ask me the question, probably then what is the remedy? Remedy is this. If you look at section 43 of the Information Technology Act, if you access someone's computer illegally without the consent of the owner or in charge of the computer, then you have a right to civil damages, which can run into crores. You also have a right of criminal prosecution. So you can use these independent remedies, and there are cases, at least in Maharashtra, with the adjudicating authorities, when husband used the mobile of wife for something, and for a litigation, the evidence went on the record, he succeeded there, but he had to face the blunt of the actions in the adjudicating authorities forum, and he had to pay the compensation. So that's how the law stands. Yeah.
There are two questions on the YouTube.
Yeah.
Ajay says, can a text message received from the bank on mobile be proved in a suit for recovery?
Absolutely. Absolutely. Why not? Absolutely. See, that's the reason I said, in fact, now to all the more, because now section 63 says that any communication device, obviously it was even earlier also, it was an electronic device, therefore it was always there, but you can always do it. And as I told you, please do it along with the certificate that is required.
This is Anand Darshan. What will be the change in the certificate to be given in pleadings under the BSA?
Nothing. My entire session, let me say this very absolute responsibility. My entire session on 65B earlier stands intact. There is not even a minutest deviation from the certification process. It is going to be exactly the same as it was earlier. Nothing would change there. It would be the exactly same certificate.
Yeah. Though we'll request the viewers to watch that. Could you just explain what is the concept of Section 65B? How does one deal with it? So that in a short minute you can explain what is the procedure for Section 65B.
65B, let me just encapsulate that for you in 5 minutes. 65B and now Section 63 basically says that electronic record, printed, copied or stored in any optical or magnetic media. Optical media matlab CD, magnetic media would mean the old time hard disks. So basically any electronic media is deemed to be a document if you comply with 4 technical and 1 non-technical condition. Section 65B says if you do comply with these 4 technical and 1 non-technical condition, electronic record can be produced in the court of law. Now, what are those 4 technical conditions? You would get that in old 65B 1, 2, 3, 4. In Section 63 now you would get in again Section 1, Section 2A, B, C, D. First condition is this: the computer output was produced by the computer during the period over which the computer was used regularly. You have to say that in your certificate. Now, why? As I told you, if you don't use any device regularly, there is a possibility of its BIOS clock, what we call basic input and output system clock, running out. When I say this, I mean the computer, and it may completely disturb the internal timing of the machine, which will have a very deep impact on timestamp. You know, in any murder trial, for example, last scene with the deceased, you know, the timestamp is very important, the time trail. In these kind of devices, suppose if a CCTV says at 6 o'clock he was seen with the deceased, and if it comes to knowledge the CCTV wasn't working for 3 years, then the timing of CCTV is completely then crazy. You can't believe on it. So therefore, the device must be used regularly is first condition of Section 63(2)(a). You have to say that it was being used regularly. B says that the information was regularly fed into the regular course of business. For example, if suppose I have to produce a computer record tomorrow in the court of law, I cannot sit in my office and input everything that I want to be produced in the court of law. It has to be regularly fed in the ordinary course of business, which is in US called as a business record exception, which if you see Section 32 and 33 also refers to our old act. So this is another statement you have to make for 65B certificate. Thirdly, you have to say my machine was operating properly. If it wasn't operating properly, you have to state the duration for which it wasn't operating properly. Okay. And fourth is almost like first. Okay, when it must be fed in the ordinary course of business. These are 4 technical conditions. What is one non-technical condition? One non-technical condition is that you have to make a certificate and you have to sign on it. Now, when you make a certificate, you have to just put your sign. It did not be even notarized, technically speaking, but it is always better to notarize it or affirm it before a court officer to prove the identity of the affiant or the signatory. So you have to talk of those 4 technical conditions and you have to sign it. But before you sign, you must ensure that you are in charge of that computer, you are in charge of that system, or you are holding some official position about that mobile or a system. Suppose, as I said, if I get the mobile of my wife and if I take printouts, am I the person who is in official position to give the certificate? If you please look at Section 63 now, Section subsection 4, earlier 65B4. It must be the person who is in charge of the system. So I won't be the person who is in charge of the system, correct? So then you are not in the position to give such certification. What do you do in such cases is told in the judgment of Arjun Pandit Rao Khotkar, on which I have spoken at length in my earlier session. You can issue witness summons under Order 16 Rule 6. You can issue witness summons under Section 165 of Indian Evidence Act, which gives the judge a power to call any witness at any point of time at any stage and to ask any question as it deems fit, relevant or irrelevant. So you can use all those sections. 191 is there. There are many sections that can come to your aid to call that person in charge to the court and sign on that certificate. So and if you comply with this one non-technical condition, your electronic record is good to go. It passes the muster, it can be read in evidence. That's how the scheme in short of earlier Section 65B and now Section 63. And for details, I will repeat again the same thing. Please visit this was a ultra quick overview of it. For a detailed discussion, please look at the session. Yeah.
We can say it is more like a T20. You can watch the 5 day. This is Tripti. Sir, recent technology has allowed people to manipulate electronic evidence, such as hacking. Does the new act shed any light on the admissibility of such records?
That's a very good question. I'll tell you very frankly. In fact, this has increased the floodgate for the problems, because as you know, the maybe a deep fake may be there, or maybe hacking is just maybe the simplest form of it. There may be, in fact, complex form of tampering with the electronic evidence. No, the act does not do anything to curb that. In fact, I must say the act, when brings electronic evidence at par with documentary evidence, you know what problems are going to be there. You could not have ever equated documentary evidence with the electronic record. How can you do it? Suppose if this is a letter written by my grandfather 20 years back, is it easy to tamper? No. If I do the tampering, you can immediately note the interpolation. But suppose if this is an email written to me by my friend, I don't need to tell you. If I have to, I can immediately edit the contents of the email. If I have to forward it to someone, I can change the contents of the email while forwarding it. You would all see that. In fact, you can try it. And if I take a printout of this email, do you think the court will be able to distinguish between the original email and the morphed email with the naked eyes? No, unless I get the hash data, hash value, or unless I get the device itself, no judge or no person is going to distinguish between the morphed one. So therefore, I don't see a point equating electronic record with the documentary record that the section 61 does. But fortunately for us, section 65B in its new avatar of section 63 still retains the position, and therefore I think there might be certain safeguards which are still in place.
This is by Ari Abraham. Medical records are now computerized in Kerala, private hospitals. Every chance for malpractices by doctors. What can be done in such a situation?
Medical records are digitalized is something I understood. Then thereafter, what's the problem?
He says every chance for malpractices by doctors. What can be done?
See, frankly speaking, as I told you, when the record is in the custody of someone, there is very little that you can do. Unless, if it's a criminal trial, you can go to section 207, where, if you look at the judgment of Dharamveer versus CBI, which requires you to give a mirror copy of the original hard drive. If you get a mirror copy, to which we also call a forensic copy, to which we also call a bit-by-bit copy, then you can give it to a forensic expert and he can tell you if that data was ever tampered, because there is something called as a trail or logs, which can always reflect if the data was tampered. But unless you get your hands on the mirror image, it is very difficult for, as an outsider, to see if anything was done internally. So you can insist on your right to get the mirror image, which is underlined by Dharamveer versus CBI, also other judgments. So you can do that. And you can get your own forensic expert to analyze it.
This is by Manoj. Whether electronic evidence is now primary or a secondary evidence, according to you?
No, that's what we spoke about. It's both now. Primary evidence, because section, as I told you, 57 now includes it to be a primary evidence. But it is also secondary evidence, because section 63 again makes its appearance, which was earlier section 65B. So my advice to you is, as I told you again, you have to reconcile it. You can't wait for the Supreme Court to come out with a verdict anytime soon. All you have to do, if you're a proponent of electronic record, please ensure, though it's a primary evidence, don't try to argue and waste your time. You can just have a certificate done under section 63 and produce it. Only thing I would say, you can be little now be confident of proving it, because it has been elevated to the status of primary evidence.
Last question, section 165, 61 CRPC. Statement made over computer by police officer. Is it now required, that section 65B certificate?
Technically, no, it's not required. I must tell you also that, 65B earlier and 63 now says that computer, something which is produced by a computer. Okay, so there has to be a, this also I have spoken at length in my last session. If something is just mere replica of what you are inputting on the device, and if it is just an output of what I have put in the device, then 65B technically won't be required.
So thank you, Mr. Yuvraj, for sharing your knowledge. And one of the suggestions was that once this comes into being, then would you like to revise your book?
I might have to, but let me tell you frankly, even I had word with my publishers, and you know what, fortunately for me, the 63 now still remains. So I don't see a need to revise the book per se, because in fact now it all the more it holds the ground. But yes, when the judgments would start coming, interpreting the positions, then probably there would be a need to revise. Otherwise, merely because section 61 elevates it to the documentary evidence or a primary evidence, section 63 still remains the same. The modalities remain the same. And the readers would know my book is not on per se 65B alone. It is on the how to disprove the contents of the electronic record and on the forensic aspect of the electronic evidence, which are going to all the more necessary in the coming time, because the defendant or the respondent to an electronic evidence will have to have a very strong burden of proof now to disprove, because earlier it wasn't a primary evidence, now it has been made a primary evidence. So I think no immediate revision necessary, but maybe down the line, yes, I would consider doing it.
The last was, it is a request that kindly share the judgment of the mirror.
That is Dharambir. You can just type it, write it Dharambir versus CBI, beautiful judgment by Justice Muralidhar, which has been in fact, repeated in many of the judgments. In fact, my book has a special chapter on how to, to get the mirror image and how to analyze it for a layman or for the lawyers, getting the mirror image and how to process it. But yes, in fact, the request would be to visit my earlier session where I have spoken at length how to even look at a mirror image. The forensic aspects were also, I think, we had spoken about.
Yeah. Before we part, this is the book written by Mr. Yuvraj, and we will share the link on the YouTube for the book. You can buy that. Thank you, everyone.
Thank you so much.
Stay blessed and happy Lodi once again, and for all the festivities. Thank you.
Thank you. Thank you so much.